even just for trying the effort, I just want to thank you all for doing that. And you know, justice is something that this country is founded on, and it's extremely important to all of us. You know, the rule of law, and so I just again want to thank you all for coming. I'm going to go ahead and start out with the first question.
Introduction.
What's that?
Introduce themselves.
Oh yeah, let's go ahead and have you guys do your introduction before I start the question. Yeah. Why don't we go ahead and have Eric? I think you're up number one, and you can go ahead and give yourself, what, we got 2 minutes to introduce yourself?
I don't think I can do that.
Okay.
That's an old joke. A lawyer is the only person who writes a 50-page document and calls it a brief. It's not very funny. My name is Eric Valley. I'm running for Mason County District Court. I'll say this only because I feel it would be remiss of me not to. My father's here, William Robert Valley, and his wife Lorena. Thank you for coming. And thank you all for being here. I welcome this opportunity to address you and also to hear from my colleagues. I said months ago I found a perfectly good way to ruin my summer. And I'm working very hard at this. I'm a 1979 graduate of Shelton High School. I did a lot of things at Shelton High School. I'm from here. My grandfather was born here. I got good grades. I went to good schools. The tag words of my campaign are hard work and personal accountability. Also, read the rules and pay attention to detail. The only agenda I have is to implement the proper and only function of a court, which is to administer the law neutrally. I've said this before in a public forum. The black letter definition of a judge, a court, or a magistrate is a neutral third party interposed between parties to a dispute, be they theoretically equal parties, or one might say the awesome power of the state and the powerlessness of the individual. Regardless, neutral third party administering the law neutrally with an eye towards reading the rules and paying attention to detail. My platform is to provide Mason County the best district court it can have for us and to show the rest of the world. Things are changing, change is here, we will be a part of it. I have personal relationships with people in every aspect of the government and the population of this county. I respect these gentlemen. I have a neighbor whose name is Darren Chacos. I'm talking with Darren as I paid him the $125 I give him every year for our shared well, and I said, after a few minutes, I said, Darren, for a lot of reasons that I had shared with him, and I've shared some of them with you, I might be the guy. And Darren said, in Darren's way, the public will decide that. Thank you all.
Okay, and if you haven't noticed, I just wanted to go ahead and clap. If you haven't noticed, we do have a timer, and so we are going to just be giving you little signs and signals so you know when to stop. All right, go ahead. John, sorry.
No problem. Hello, my name is John Donen, and I am also running for Mason County District Court Judge. I think that you should all be very pleased with the caliber of candidates that we have, not just here, but in almost every office this year. Exceptional people, all of them intending to work hard for our community. I've been here for almost 17 years now. I've had the same office on the corner of Arcadia and Highway 3. I'm a general practice lawyer. Up until I put in my materials, I've worked for vegetables, I've worked for pies, and I've worked for international corporations. I can now say officially that I also work for chickens because I'm going to have a chicken coming next week. I love what I do. I do what I love. My mantra, I say, for my campaign: justice, fairness, you to know, I have 30 seconds left, so I'm going to be fast. Rose Nye and her husband created the gym. They created the movie theater, and they serve as an inspiration to all of us as to what Mason County is and can be. Inspiration is what I'm here for. Thank you.
First off, I want to thank this organization for putting this event on for the judicial candidates. As we know, Judge Meadows has done a great job. However, we still continue to face many challenges in the court systems in this county. One of those is an overall just general lack of resources, making sure the courts have sufficient resources to get their court missions done. A more serious subset of that, however, is lack of adequate jail space. And that impacts the court's ability to have the orders be effective, have sentencing alternatives be effective, and these are challenges that we're going to face. We're going to need a judge that has experience to keep the court effective. I've been the municipal court judge in the city of Shelton for the last 9.5 years. I've had to make many hard decisions. Some of those decisions are decisions I did not want to make, but I followed the law. I've been fair and respectful to the attorneys and to the litigants on all sides that come before the court. At least I've tried to. I've made creative solutions to various problems to make orders effective without having to burden the jail any more than is absolutely necessary. And I've been a voice for reforms, and that's something the judge needs to be, as a voice. I've made my concerns known to the Criminal Justice Committee and other places. I don't want to leave you with the wrong impression. I don't have any desire to incarcerate everybody, far from it. But without a credible option of being able to incarcerate when the need requires, the other alternatives, the sentencing alternatives, pretrial orders, people showing up, are not going to be effective. I'm also a commissioner on the Washington State Traffic Safety Commission, having been appointed by the governor. The bottom line is, it's my position that I have the most judicial experience here. I've actually been a judge of a regular court for the last 9.5 years, and I do care about this county. Thank you.
Good evening. My name is Eugene Austin, and I'm not actually running to be the district judge. I'm running to serve Mason County as a district judge. I've been an attorney for about the last 27 years, and sometimes it seems like a long time, but I hope my talking doesn't seem that long to you. You know, next month, we're going to be celebrating the 242nd anniversary of the birth of this nation. And, you know, I think this is some time to reflect on what the founding principles were. In the Declaration of Independence, they set out the reasons for splitting from England, but they also established what the principles of this government was going to be. And you'll all recall the words that it says, we hold these truths to be self-evident, that all men are created equal. They are endowed with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just authority from the consent of the governed. That's, if you've ever wondered what American exceptionalism, that's what it is. Most people that lived on this planet lived in tyranny, and for the first time, the United States was set up to protect your rights, the rights of individuals, rather than getting your rights from somebody, some government, some king that came from God. And that's stated in our Constitution, and that's what the purpose of each of the three branches of government is, to protect those rights, and no less so the judicial branch. And our state constitution is similar. The district court is there to protect not only dispense justice, but also to ensure your rights. And that is very important in the district court, because that's the first place where people usually meet the judicial system. If we mess it up there, it just flows out to everywhere else. I ask for your vote, and since I'm done, I'm going to be done and sit down, which is against my nature.
So I'm Stephen Greer, running for Mason County District Court, and pleasure to be here tonight. I've been a part-time judicial officer, pro tem judge for 25 years, serving Kitsap and Mason County. I've been on the Mason County District Court bench. This is my 14th year, my own regular calendar, a couple times a month, and also fill in for your outgoing judge. I am running because I think experience is needed in the district court to go forward. I've written the district court's probation manual, this electronic manual. I'm the first one to flip on the computer system in the district court while Judge Meadows out of town, just to surprise her for fun. And while she's gone right now, I apparently am going to start first video arraignments from the jail for the county district court. There's a reason behind all this, also behind my work with the administrator right now, to move to a paperless court. A lot of pressure from Olympia to do that. Ordering paper forms is not cost effective anymore, and it needs to be done. So I'm helping to design those electronic forms. My experience in other courts, as well as this court, is helping me a lot. Also, resources are an issue. 8 clerks are doing the job of 10. Those 8 clerks can do the job of 12 if we go to a paperless court. It's been done in other counties. So it not only saves money, but it's better for the employees as well. As far as jail space that was brought up, I want to thank the sheriff who's here. It's not really an issue anymore from my perspective. When I need to put somebody in jail, they go to jail. The sheriff is renting space in other locations. Not the best way to go, but it's a reality. And it's greatly appreciated. Jail alternatives, when appropriate, are also a good thing. We have a probation program where people on probation pay their own way for their punishment. I think it's also a good thing since they did the crime. Anyway, bottom line is, I think experience in district court matters, and thank you very much.
Okay, thank you so much for introducing yourselves, and we're going to go ahead and go into the question phase at this point. I'm going to go ahead and ask the first question. Who here got a list of the questionnaire that we sent out, the King County Bar Association list of questions? Anybody get that? Anybody? No? Oh, nobody got that? Oh, one person? Oh, did you folks receive the list of questions?
I did. Yes.
The link, at least the link to the list of questions. Okay.
Link.
Anyway, we were kind of using that as our template, and I'm going to go ahead and ask the first question, and then I'd like to ask the audience to come up with some questions, and if you guys don't have questions, I'm going to be forced to ask more questions. So I'm going to be asking for questions, and then I'll proceed forward if nobody volunteers. So for our first question, we're going to start with John, and then we're going to proceed in the same order as we went last time. What do you see as the overall duty of government, and how does the judicial branch fit into that?
Oh, thank you. That's a great question. Should I hold the microphone?
I think holding it up close would be good,
Okay.
Speaking into it.
The duty of government as a whole is to properly serve its citizens. More.
Kiss the mic.
Kiss it. Okay. The duty of government as a whole is to properly serve its citizens, to recognize and understand what fiduciary duty means, to be good stewards of our budget, to understand that as a government we have to work as a whole, share our resources, share them between departments for the betterment of the community, work together, and figure out what we can do at a time of economic crisis to make sure that Mason County is the best that it can be. In terms of the judiciary, we have a district court, we have a superior court. I did have a conversation with the superior court clerk, Sharon, asking her what she thought needed to be done in terms of having a more streamlined district court and superior court, and the answer was communication. There seems to be some issues with the latest computer programming. She was a strong advocate for trying to increase the level of communication between the two courts, because oftentimes there are some things that interrelate. In terms of the duties that we have, one of the primary duties is obviously the duty to be fair and impartial and to properly administer justice, to properly serve our community is critical. My opinion is we need to catch people in their first and second offenses, and we need to teach them how to become good citizens. One of the alternative sentencing provisions is MRT, which teaches people how to understand the gravity of the impact of what they're doing, to help them become better in society. And I'm done, but I'd talk about the budget if I could. So.
Thank you. Go ahead, George.
Where I see where things fit, we have a divided government, and what I mean by that is even on the local level we have branches of government. The court is a judicial branch of government. The judge of the court is on the same level as the executive members of whatever that government is, whether it's the city council in the Shelton, whether it's the county commissioners in the city, or in this county. The purpose of the court, and where that fits in, is very simply to apply the law, to make sure justice is done. The court is not here to create policy, the court is not here to create law, but to apply the law and make sure that it's fairly and impartially administered. I do also believe, and I want to be real clear, that I do very much believe in sentencing alternatives. We have a very great community service program with the municipal court. However, I've had firsthand observations over the years of what happens when we don't have the ability to back those orders up, and that has been the case for some time. I want to be very clear, because I don't want anybody to have any misunderstanding. I am not blaming the jail. If there's no room in the inn, there's no room in the end. It's simply math, and that's the situation we have. So, but as far as the court goes, it's to fairly apply the law and make sure that justice is done. And that is my answer.
All right. Thank you. Eugene?
Right, so, question of overall duty of the government, as I mentioned in my opening statement, the overall duty of the government is to protect your rights and see that they're fairly and impartially enforced. It's not to, as Judge Steele mentioned, it's not to create law, not to create a law that should be done by the legislature and that type of thing, but it's to enforce the law and interpret the Constitution. You know, Alexander Hamilton argued that if you allow the courts to take on those other areas that are properly meant for the executive branch and the legislature, you can't have freedom. Because the purpose, you can only have freedom if the court is going to do what it was meant to do and stay within its bounds. Now, to do that, the court's going to have to meet, challenges, and you've heard some of those challenges. The jail is overcrowded. Alternate sentencing is a good way of helping ease that. There are some issues because we try to make the person that's sentenced on that, pay for it, and not all the people can pay for it, and so then they still end up having to go to jail. We have problems with the court and how efficiently it operates. Currently, the jail has to bring their inmates up. They have to chain them up, bring them up to the court. They have the hearings, then they have to take them back down, unchain them, bring get new prisoners in line and bring them back up, and that delays things, as some of you have mentioned. One of the things that we might look into trying to do is utilizing the multimedia thing and having the jail, maybe those small hearings, the arraignments, done in the jail via telephone and TV. Yeah. We're done.
Okay.
I'm not done, but we're done. So.
Eugene? Oh, Stephen. I'm sorry.
I'll check. Stephen, you took away my mic.
Well, yeah, share that one.
I'll share.
There you go.
George will share. Thank you, George. Jane. So, I like all the people up here, and unlike Eric, who talked about how briefs are 50 pages for attorneys. I believe that briefs should be brief and judges' decisions should be even shorter than the briefs. So I'll be very short with my answer. The duty of government is to serve the people. That's it. Not serving the people, then you got to change it. When it comes to judicial branch of government, we are a separate branch of government, as George indicated. And judicial duty is to follow the law and apply the law, period. The legislative branch of government decides what the law is. The executive branch enforces the law. The judicial branch applies the law. That's very simplistic. Then there's the reality. MRT was mentioned. I'm a mental health attorney. That's moral recognition therapy. It's kind of like AA for criminals. It is fully self-supporting by probation fees that are collected by the district court. I believe you have to pay about $5 for the book, and after that, those on probation pay all the fees. And it is a great program that reduces recidivism, and we don't have to pay for it, they pay for it themselves. Jail alternatives, I think, are a great thing. Weighed against public safety. If you can release somebody in Scram X, a device that's electronic home monitoring plus an alcohol monitor, and you can keep the public safe, that's great. Putting people in jail is expensive, but public safety is paramount. If they need to go to jail, again, that's where they go. That's just reality. But what hasn't been mentioned is the district court has other judicial duties, name changes, domestic violence orders of protection, sexual assault protection orders, anti-harassment orders, civil lawsuits. It goes on and on. The district court does a lot of things. And to give you an idea of how the judicial duty is in Mason County District Court, on my average calendar, I have about 60 cases to do in 3 hours. So if you got your phone with a calculator, figure it out. You watch the court for security reasons, make decisions, and move on to the next case. You got about 2 minutes a case or less. Thank you.
Okay, Eric.
Excuse me, I won't stand. I started to. I'll bring this microphone over, though, if I may. We're ready to go. Purpose of government, people, is to govern. It's that simple. The role of the judicial branch is to safeguard our democracy and to act as the guardian of due process. Due process has two parts. They are fundamentally important. Notice and the opportunity to be heard. I'm the fifth candidate to address this question. We all took civics. Nobody said checks and balances, and we all should have. There are three co-equal branches. The judicial branch is getting pushed on, and pardon my father abhors my poor diction. But the judicial branch is constantly being... There's an inherent and eternal tension between the judicial and the legislative and the executive. The executive, through administrative bodies, will impose regulations, such as the Department of Licensing, which are always changing, always growing. This is the Republican Party. These are conservative people. Too much regulation, perhaps. I respectfully disagree. It is not a court's, and I may be wrong. Every time I open my mouth, I might be wrong. I tell my clients that. They don't like, I'm frequently wrong. But my father has a line, and it's not about my dad, but I like it. It's a good joke. I made a mistake. I thought I was wrong. So, it's a court's job to protect the rights of the minority against the majority. And so there's that inherent tension, again, checks and balances. The courts are the safeguard because, and I didn't even talk about the legislative branch, but you know, they do what they do and then the executive implements that, and the courts, again, like I said, I don't know if I said this, I want to be in the middle. I've been an advocate for 34 years, including a couple of years in law school. I graduated law school in '87. This is my 31st year as a licensed practicing attorney. Thesis, antithesis, synthesis. That's the court's job. Sit in the middle, figure it out, keep people honest, safeguard people's rights. Thank you.
Okay, I'm going to go ahead and entertain questions from the audience. So if you have
Testing,
questions,
testing.
please raise your hand, and we're going to get somebody around. We just have to do the whole work.
I believe so. This one's working.
All right, Marty.
Yes, I've been a juror in Thurston County and in Mason County. My jury training usually consisted of a 15-minute movie just before I went to the jury. I think civics education is lacking in this country. Jurors are often ignorant of their responsibilities. So, what is your judicial role to train jurors to avoid jury nullification, Jury decisions based on juror political or personal beliefs rather than the evidence, or what attorney Gloria Allred called the blinding power of celebrities. Also, will you be able to remove your own personal and political biases when making rulings?
Okay, so we're starting this time with George.
Okay, well, that's an interesting question and a very important question. First off, you have to be careful about how much you educate a jury. And that can be very frustrating for juries because I do not want to educate them into my bias as a judge, because here's the situation. When you have a jury trial, the judge is really there, unless there's a conviction, as a referee, called balls and strikes. It's ultimately going to be up to the jury, and I've told many juries in my jury trials, as a prosecutor and as a defense lawyer, that jurors have the most important and active role in any jury trial. I do share a concern about people not having a good knowledge of civics. Part of the way we do that is through jury instructions, but part of it is just simply the fact that we do not inject our personal bias. That means we allow the attorneys to conduct their cases. They know more about their cases than any judge is going to know. And it's going to be largely their job to educate the jury. It's also going to be a situation where we go through jury selection. And I will tell you that there is a movement, I don't know how strong it is at this point, but there's a movement in this state that many people want to remove the right to peremptory challenges. And for those who don't know what peremptory challenges are, those are challenges an attorney can just simply make, or a defendant can simply make without having to justify. That gives both sides some control over who's going to decide the case. And I think that's critically important, but trust me, it's under threat. There's also challenges for cause, and that's where the court will grant the challenge or not. So the main way we do this is through jury instructions. We also question the jurors so we know who's fair, who can be impartial, to the extent we're able to know that. And absolutely, I do not inject my bias. I will tell you, I had one case, I'm not saying who, but I never told the attorney this, but it had been a bench trial, I would have acquitted him, but the jury convicted. And I had to apply the law as a conviction because that's what happened. Thank you.
You got more training than I did when I was the judge's job is not to try to teach people that jury nullification or it's actually part of our legal system, and it's allowed. The jury is the final arbiter of what the verdict is going to be. It's not for the judge to tell them vote one way or the other. And one reason why we don't tell them about jury nullification is because we don't want to influence them in that way. We have jury instructions that are designed to inform the jury of how they're to apply the law. The judge is there to help explain that. The judge will make rulings on specifically on legal matters in court and allow the jury to determine the facts. The attorneys are also there. They help determine what issues need to have better instructions. And they have the opportunity to present their case to the jury. So we don't want a jury that's already made a decision. So that's sort of like a... You're right. Civics are not taught in our schools anymore. And it's a very troubling situation. We need to have people that know about the Constitution, their form of government, so that they can make those proper decisions when they're in the jury. Since we're almost out of time, I'm just going to tell a story. When I was in law school, I took a trial practice class, and we had a real jury. They came from the business school. So they weren't dumb people. We had a real judge, and they were sworn in. We did the case, and they let us listen into the jury instructions and the jury deliberations. This jury went back there, and within 2 minutes, they determined my client was innocent, but they found him guilty because he looked guilty. So there needs to be some concern there to make sure that the jurors know what they're supposed to do.
Thank you. So first of all, I want to mention, I'll try to hit all the points of your question. The 15-minute movie, I've never seen it. So I can add it to my list of things to see. Sounds like it's not that interesting. But anyway, I will take a look at that movie. But otherwise, I'm going to echo a little bit of what you've already heard, and that is, you get that brief movie, should civics be taught better in schools? Yes. I had civics in school, and it seems to be disappearing, it needs to come back. However, when it comes to reality of the courtroom today, yeah, that boring 15-minute movie, I've heard that part. And then, my role as a judge is to be impartial. You get the jury instructions. Jury instructions are vetted very carefully by judges all across the state and based on case law and the law before the court. And we are the referee. When there's a jury trial, the judge's job is just to be the ref. Sometimes juries make decisions. I wonder how it happens. Sometimes they make decisions and I go, duh, that was obvious. But my job is to be completely unbiased at all times. In fact, some of the jury instructions tell people, actually do say, that the court has shown any kind of bias of any kind, you are to ignore it. And that's important. Every time a jury trial ends, and I've done over 100 of them as a judge, I thank the citizens that have given their time, because you've left work or retirement playing golf, or you went fishing with your grandkid, whatever you want to do, and instead you've been in the basement of the courthouse with me doing a jury trial. And to this day, after 30 years of practice, when I tell the members of the public who served as jurors that I've appreciated what they've done, and it's important to our Constitution that they did it, not me, not law enforcement, not the attorneys, I start to cheer up a little bit, and the clerk gives me a bad time. But I really mean it. Our job is referee. The juror's job is to make the decision. Thank you.
Thank you. Here are my notes. The last two words, the second and third of three are heavily underlined. Juries are it. That's the heart of our system, and I love it. And this is something I didn't think I'd think, you know, because I'm not much, but I'm all I think about, is an old saying. I get to do that. We all get to do that. And I talk to jury pools, and I ask them, I say, who's the most important person in the room? And they always say the judge. And then you say, no, it's the jury. And then you tell them about Harry S. Truman, and what is that thing he had on his desk? What did it say? You all know what it said. It said the buck stops here. It stops with the jury. Now there's a jury pamphlet. And I've challenged this jury pamphlet to jurors in Superior Court and District Trials. Well, no, Superior Court, because I don't know that the District Court says this one. But I say the same thing. You may hear that your job is to determine what happened, and that's a false statement. That's incorrect. And the judge didn't stop me, and the prosecutor didn't object. Why is it not a jury's function to decide what happened? Because no one knows what happened. There are potentially, and that's the truth. And it's not a jury, because nobody can, that's not the issue. The issue is to see whether either party has met their burden of proof. In the case of a criminal trial, the issue is whether the prosecution has proven guilt beyond a reasonable doubt, whether they have erased the burden of proof. So that's just, and I do not mean to be flip. People have lived and died to preserve the jury system, which comes to us from the common law, from England. That's the heart of our government. Now, how do you keep jury bias out of it? Really, really, really easily. Part of that, though, is by watching good role models. There was a judge when I was in law school at Tulane in New Orleans, a federal judge, and I heard him say this. He says, "Counselor, I see you're wearing the same ill-fitting blue blazer you were wearing the last time you were in my courtroom." That's a bad judge. A good judge was Judge Sawyer in this courtroom, in this county, who said wonderful things such as, one time, and I had no idea where he was at. I said, during a break, or maybe I said, "Did you think we stood a chance of winning?" He said, "Eric, you ever see that Snoopy cartoon when Snoopy's all excited, He says, if you would have won that, Snoopy would have been doing a dance on top of his doghouse. But he gave no indication during the trial where he stood. That's how you do it. Thank you.
Thank you. Number one, jurors are people, judges are people. Number two, we work in an adversarial system. We have one party being represented by someone whose job is to advocate to the fullest extent of their ability for one side. We have another party whose job it is to advocate for the other side. The jury instructions are actually very important. The majority of them are drafted by it's a book called the Washington Pattern Jury Instructions. That's what you look at in terms of, you set the templates. But the jury instructions are actually negotiated by and between the advocates,
presented to the judge, who then makes a determination as what is proper and what is improper to present for the jury instructions, which are your instructions as a juror. When you're talking about the issue of jurors and the concern about education, the answer to that is actually public service by your judiciary, public service by all elected officials. Go out, reach out to people, teach them to the extent that you can. Have classroom days where you're bringing in the sixth graders to talk about the judicial system. Do things to cause inspiration, do things to make it an interactive process for people. I'm going to tell you something that I believe based upon my experience. I believe that jurors take their jobs seriously. I believe that they have a belief in tremendous responsibility for the position that they're taking, and I believe that they want to be fair, they want to be just, and they're looking for guidance. In terms of bias, the answer to that is you show no bias. Every person in the world has bias. If you stand up here and you say, I have no biases, you are lying. Everyone has biases. The ability to distance and create a distance between those biases and objectively present and address the law based on fairness and impartiality, and to effectively steward the entire process as a referee.
Okay, let's go ahead and go on to our next question. Nancy in the back corner there.
During notification, I'm going to speak as an uneducated juror and now an educated juror. And Judge Steele, I believe that you said that jury found someone guilty and you would have found them innocent. Am I correct?
Yes, are we going down the, I'll answer your question, but yes, I did say that.
Yeah, correct.
I won't say who that person was.
No, I don't, it doesn't matter. But the point is, a law is not always just. A law always is not constitutional. And even though the prosecution can find someone guilty, does not necessarily mean that person is guilty. And jury notification is very important for a jury. Now, as judges, how you give the jury instructions, never have I heard anything in the jury's instructions that really give them the power to use their own mind. The trials I've been at is the judge is king. I'm not saying you guys are, but the judge is king. You kind of look at their authority and what they say goes. That's not true. Jury nullification is crucial to our judicial system. And I would like to know if you would add into your jury instructions jury nullification.
Okay, and let's start with Eugene on that.
You're correct that that's a proper part of our system, that the jury can do that decision. Now, I've thought about this on occasions, and there's been a couple occasions where I thought that it might actually be appropriate. I can't remember what they are because you just asked the question for some reason. If you'd have talked to me last week, I probably could have thought of something. But generally, we don't do that. We don't tell them. We don't tell them not to either, because the jury, you don't want to prejudice the jury one way or the other. And the jury's job, and as it's been mentioned in a criminal case, they're supposed to look at the evidence and determine whether the prosecution met its burden of beyond a reasonable doubt. In civil cases, the standards are lower. But it's the jury that has to weigh those facts based upon that. Now, there may be cases where a law is unjust. Hopefully the judge would, if it's unconstitutional, would have some sort of make a ruling on that there'd be a motion and you make a ruling on it. I suppose if the law called for someone to have his hand chopped off, I would expect the jury to say, no, we're not going to convict him of that because that's not appropriate. But it should never get to that point because the way our system's set up, that should be ruled unconstitutional, like sort of a penalty. So I think that's one of the reasons why we don't do that, because the danger is prejudicing the jury one way or the other, and we want them to make concerted effort to apply the facts and then make the decision based upon their conscience and what the facts were as they were presented in court. And if we start telling them, oh, you don't have to do that, then you're going down a road that is not good. So that's why we don't do it.
Okay, I just want to make sure, does everybody understand jury nullification?
No, absolutely not.
Okay. All right, so I'll just give a quick, basically it's a jury nullifying the law. Is that correct?
Yeah, the jury, where despite what the law says, you don't trespass, and the guy trespasses, but for some reason they think it shouldn't be applied in this situation, they just say, we're not going to convict him.
Okay.
It's
So,
nullification.
So, you know, maybe something that applies to this would be, does everybody know Martin Luther King Jr.? So, has anybody read the letter from Birmingham jail? He talks about unjust laws, which was Nancy was talking about, and so that's probably a situation where maybe the jury would you know, back in the 60s or something, somebody's taken in from a lunch counter and trying to be convicted, and the jury says, no, we're not going to convict that person. Even though we know that the physical evidence shows that they committed the crime, crime. Does that make sense?
More to the point case would be going back to your criminal trespass. If somebody saw on the other side of the property line someone having a heart attack and they ran over for CPR at that point with the jury. In this case, the law does not apply.
Okay. All right, Stephen?
George took my pen, so I'm going to take this mic. So, for jury nullification, I'm glad it got explained now, so that helps a lot. Answer is I can't do it. I can never instruct anybody to do jury nullification. Does it happen? Yes. The court's job is to follow the law. And during trials, you know, jurors are told the judge is going to give you the law, and you have to follow the law. That is correct. That doesn't mean we're in charge of the law. The law was written by the legislature, and you elect them. And they write the law. And jury nullification has a long history in the United States, and the civil rights movement is one of the examples. Let's go to medical marijuana, recreational marijuana. There's always an issue for some generation, same-sex marriages, those hot-button issues. If something's made a crime and the citizens do not believe it should be a crime, then jury nullification is when they come back and say not guilty when the crime says the evidence shows they are guilty of that crime. That's jury nullification. As a judicial officer, I cannot tell you to violate the law. However, when jury nullification happens, it sends a very powerful message to the legislature, the people that write your law, that the people are saying it's wrong and you should change that law. But I cannot change that law, and I have to tell you what the law is. Then I have great faith in jurors. Whether it's nullification, guilty or innocent or hung jury, I respect their decision because the laws written by the legislature when it comes to a courtroom are eventually enforced by the jurors. And you will send a message, and I think that's an important message if that's the message you send. But I cannot tell you to do it because that's not the role I'm allowed to play.
Thank you. Back to the common law. For a long time, in England, there was law and there was equity. Equity was run by the chancellor, who literally was known as the king's conscience. So we inherited the jury system from the common law from England. It is, I won't say sacred because sacred means connected to the divine, but it's profoundly important to our lives and to our system. So you can't. It makes no sense to inform a jury that they can nullify because jury nullification by definition is going outside the system to act as it were as the king's conscience. Examples are libel of colonial governors when nobody liked them anyway. So the facts supported it, but they're like, we're not doing it. So it's back to that, who's the most important person in the room? The jury. So, again, referring to my notes, and I think I just said everything that was in them. I'd just be repeating myself if I said the same thing again. Thank you.
Thank you. The short answer is no. First off, I neglected to mention in the last question, I've seen the video, and I've watched, and I've read the pamphlet, and I've drinking the bad coffee. I understand what happens when you're waiting to be called. One of the things that's important to understand is when it comes to the topic of jury nullification, the idea is that if the law is unjust, if the situation is wrong, the people, a jury of your peers, are going to know this will not do. That's the idea. And when you deal with a situation of jury nullification, it would be improper to, I believe, it would be improper to sit there and instruct people along with all the other instructions. And if you don't like the law, you can avoid the law, because what you're swearing to do and what you're watching a video to and a video about and what you're reading a pamphlet about and what you're drinking bad coffee over is a promise that you're going to do the best of in the best of your ability to apply the law. And if it's in your conscience, if it comes out to you that
Those words are not there, and they were the law of the land for about 70 years. So I have very strong views about that. Thank you.
Good, all right, I'll take another question, and this round we're gonna start with Stephen. Pat? Can we get a microphone, Joe? All right, speak up.
So the Washington State Constitution starts off, Article 1, Section 1. All political powers inherent in the people. Governments derive their just powers from consent of the governed. This is where my question comes in. It ends with, and are established to protect and maintain individual rights. How would you, as a judge, what's your opinion on individual rights versus group rights? I don't want to put any specifics out there, but let's make it as specific as possible. Ruling in favor of unions, secret.
Thank you. As I think Stephen said, and we all know each other, we've all worked together, so I don't think there's any inappropriate informality by addressing each other by our first names. And now I forgot what I was going to say about what Stephen said. Here's what I'm getting at. Our state constitution is more protective of individual rights than the federal constitution. The federal constitution says we can be free from unreasonable searches and seizures, whereas the Washington State Constitution says we have the right to be free from intrusion in our private affairs. Now, if I've gotten the exact language wrong, I apologize. And now I remember, and that's why I should stop before I forget again. This is not the kind of thing likely to come up. It's never going to come up in a district court. That case would not be heard in a district court. And if it were going to be, we couldn't talk about it. And so I apologize that I'm in a wishy-wash on your question.
It's just an example of group rights versus individual.
Well, and I struggle with this, but again, we haven't heard of it yet. That may well arise to the difference between a republic and a democracy. You know, the form of our representational government. I say may well, I think it does. I think it goes to the heart of that. And that's a fairly, and when you look that up, if I could give you a law school, professor to student, student to professor, I understand it, but I can't explain it. And the professor said, well, if you can't explain it, you don't understand it. So I'm not able right now, and I wish I were, to talk to you about the difference, but I know that it's important, and I know your question is important, and that's where I come from. Individual rights. But, again, it's not about me, and it's not about you. It's about us. I said that once in a meeting, and a guy referred to a song where the line is, anyway, it doesn't matter. The guy said, I just want a Pepsi, We're all in this together, and that's a judge's rule. This is the worst answer to any question I've ever given. But again, that's what it's all about, and that's what I want to do. I know the values of this community, and that's what I want to do as judge. Thank you.
Thank you. So your question's valid. Unfortunately, your example's a little bit off because what you're talking about is actually something that would be governed by a doctrine called federal preemption. Issues related to unions and issues related to collective bargaining are things that are actually governed by federal law. And if we were even to use those words in court, in a state court, I can guarantee the attorney representing the union is going to stand up and say, we're moving to Tacoma for the federal court. But your question is very valid, and I'm going to apply it to the reason that I went to law school. I went to law school after getting a degree in the media
and working in media. What happened in law school, I went to a class called Media Law, and I met an attorney. And my belief is in the First Amendment. At that time, I felt that I needed to really become a staunch advocate for the First Amendment. The idea being, I don't have to agree with what you say to defend the fact that you should be able to say it. That's an individual right. When you look at the Constitution and you consider the Constitution, you apply the Constitution for the people and for the person, and you apply what's written. But in district court, the kinds of things that we do, we will be looking at issues related to the First Amendment. We look at those in dealing with anti-harassment orders or in domestic violence issues, because there are exceptions to what can be subject to restraints. So we have to look at those types of things, and there are some balancing tests that we learn in law school. They call it the Matthews v. Eldridge balancing test, and some case law that talks about those things, that we have to use judicial discretion in looking toward. But the reality is that you have to look at every case, but you are also looking at the language and applying the language properly. Hope I've answered.
Okay, and to a certain degree, I will not be able to answer your question as far as, because that starts to get into the realm of how it hear a case or whatever. And it's not likely these things to come up in district court as much, but they can, because district court also has a fairly extensive civil jurisdiction as well. That's one difference, frankly, in all fairness, municipal court, where I am, does not have. What I will tell you is this, though. My philosophy is, government didn't give me my rights. They didn't give you your rights. These are rights that we already have. And all these amendments did, like the First Amendment and the Washington.
Now, in government, I've taken an oath to uphold the Constitution and defend it against all enemies, almost 5 times. 3 times is in different jurisdictions as an attorney, and as in the Marine Corps, they take pretty much the same oath, that they're going to defend the Constitution, not somebody else, but the Constitution, and that protects your rights. The state Constitution can guarantee more rights or more protections than the U.S. Constitution, but it still comes down to your individual rights. To the extent that a group is trampling on those rights, that's improper, but as we said, the district court is not going to hear that particular case.
Okay, I realize we're running a little bit behind schedule. We're going to go ahead and have closing statements at this time, and we're going to start with Eugene.
Well, how long do we have for closing statements? 2 minutes again? Okay. Just continuing on from where I was, that the purpose of the 3 branches of government are to defend your rights and apply, ensure that they're protected. The courts do that by dispensing justice in a fair, impartial, and proper manner. Our courts have a number of issues. The district courts has a number of issues that are facing it. Their caseload is a problem. Working with the jail, and the jail does a great job, but it's hard to transfer people up and down in that.
With the IT departments of the county to look at their computer system for paperless court. It's a painful transition. I went through that transition in Thurston County, where I pro-tem occasionally. I went through that transition in Kitsap County. Everybody has a different computer system, and the question comes down to what can we use here that we can afford here that will work here. Again, the staff is great. They're overworked, like many county employees are. But there's a solution. The solution is going paperless, getting a computer system on board, little things, mitigations by mail, contested infractions by mail. We do that partially right now. We need to switch to doing it to be available to everybody. I want to switch that over to a computer email system where it's encrypted messages and you have a key code to get in to do your ticket. That's done in Bremerton. so you can do your traffic ticket by computer if you want to and not show up to court. These are all little teeny steps to reduce the workload in the court and make things more time efficient. It's not just about theory, it's about reality and getting the job done. Thank you.
Thank you. Sorry for being too loud. Speaking of dignified, articulate court, Judge Meadows brings in, and this is not a slam on Judge Greer, on Stephen Greer. Judge Buzzard comes in, commands respect. I've heard people tell me that since Judge Sawyer retired, and I'm not trying to invoke a specter or a respected figure other than for any other reason, that someone said after he retired, we have not had a judge in this county who commands respect. I like Dan Goodell. I think he's a great judge. I like Amber Finley. I like Monty Cobb. Been a judge for about 3 weeks now. I think Judge Meadows did a great job, etc. Okay, but that's what we need. That's what we
And the success rate with my clients about that, because one of the things I realize is that it's about people. It's about reaching them. It's about talking to them. When you're going through alternative sentencing discussions with your client, with my clients, and what I intend to do from the bench is going to be, well, look, this is what the law says. If you want to go through a diversion, you've got to go do X, Y, and Z. This is what I tell my clients when they come to see me if they want to have a diversion. You're going to go ahead and do that, and as a judge, what I tell the clients is the judge is going to be bound to follow that because that's what it says. You have to do this. What I tell my clients is, good luck getting the job after that, though. Here's what you need to do. If it says you need to do, if an assessment says you need to do 2 AA meetings, you're going to go to 4 because you want to turn it around, because you're going to use this as a chance. I believe that inspires people to do better, to be better. The other things I want to tell you is when it comes to what we're talking about now, we are in a financial crisis. Judge Meadows wrote a letter to the commissioner, and I want to quote this. It's November 1st, 2017. District Court has not been properly staffed for several years. We have managed to get by, however, the service to the public is compromised. That will not do. We need to be better. We need to do better. We need to try to work with what we have. You'll find an interview on Web TV. I encourage you, when it comes out, to listen to what all of the candidates have to say. Thank you.
Again, I want to thank this organization for putting on this event to allow people to have a chance to meet the judicial candidates. I believe that's very important. As we've all indicated, we face many challenges with our court system going into the future, and I believe its experience is going to be needed in order to address those challenges. And my court is not a one-day anybody, the sheriff or anybody else. My criticism is directed towards the situation we find ourselves in.
If I might. The issue of how to get something funded is resolved not by pointing fingers at anyone. It's by working collectively and with creativity to come up with a solution. I don't know if you guys know it, but about 47 cents out of a dollar of a traffic infraction gets to stay with us. I don't know if you know it, but we need to work together when we're trying to figure out a budget. We need to figure out how to get the things that we need. And quite frankly, we need a jail.
We've got 2 more candidates. I think it's only fair to give them 30 seconds here. Go ahead.
I'm going to go way out on a limb and predict that in the next 20 years, we're going to have a new jail. We're going to have a new justice center. I don't know how it's going to happen, but I bet you money, I bet it's going to happen. And now is not the time to say that that courthouse downtown was dedicated the same year my father was born, 1930. It's 88 years old. It was built in 1929, dedicated in 1930. To say we need thank you all very much.
Sure. So I believe new jail, new justice system's been on the table for over a quarter century. Hasn't happened yet. Court can't control that. So it's just dealing with the reality we have now. Should there be a more modern jail? Yes. I was in the jail last week, taking a tour of the jail and checking out the video system in preparation for this week's video arraignments. It's extremely out of date, and it's a safety issue, I think, for the correctional officers, and that would be the sheriff's expertise. But I think it is a safety issue for the correctional officers, for the inmates, for the defense attorneys to go in there. And it really comes down to a risk management issue. Eventually, hopefully, the county commissioners will realize that avoiding a multi-million-dollar lawsuit for something that goes wrong is more expensive than expanding the jail system or increasing funds for the criminal justice system. Is the criminal justice system expensive? Yes. In every county in the state of Washington, your law and justice system is the biggest chunk of your money.
That I've been most passionate about of any position I've ever had. I have the knowledge, I have the experience, and I have the proven leadership to do this job. I was given 2 appointments by the governor to represent all counties in statewide issues, one transportation, one emergency management. I've worked with people at the federal level, the state level, all on your behalf as a county commissioner. And this is where my passion is. My family's been in Mason County forever. My children are 4th generation Mason County residents. We have a reason to be good stakeholders here, and I just want to continue the service that I started before. Thank you.
Are there any other Republican candidates here? Doug Deitman, is Doug Deitman here? No. Any other Republican candidates? Okay, one candidate did call and talk to me, a guy I've worked with before, Art Code. He is running for U.S. Senate, and he has a strong